All right, good morning, everyone, and welcome to the Wednesday morning docket of the Court of Appeals. I'm your presiding judge, Mike Boozer. Joining me today, we have Judge Steve Hill, who is the longest serving judge in the state of Kansas, and the shortest serving judge in the state of Kansas, or one of them, my colleague, Judge Leslie Isherwood. And that is your panel for today. We have 30 minutes total for arguments. On the first case, that's 15 minutes to a side. The appellant needs to let me know how many minutes you'd like to reserve in your argument for rebuttal. And with that, I think we can begin with the first case of Huffman versus StormontVail. Ms. Huffman?
Thank you, Your Honor.
How much time would you like for rebuttal?
7, please.
7 minutes?
Yes.
All right. You'll have 8 minutes for your opening statement.
Right. Thank you, Your Honor. Although the parties filed briefs and a reply in this matter, I think the case is pretty clearly at this stage that we're lacking substantial competent evidence, because regardless what the trial court did or did not do with the amended pleading under 6215, the fact is that under Rule 141 and Supreme Court precedent is briefed that the defendant has to show that they're entitled to summary judgment, which requires an absence of fact based on evidence. And the exclusive 19 facts that was presented by appellant neither established an absence of evidence, nor were they briefed or addressed by the StormontVail, 1 through 6 being purely procedural, 7, 9, 11 through 13, and 10 were just portions of the plaintiff's petition, which leaves them 6 possible facts. Number 14, a portion of an unverified letter. And that does not establish an absence of fact. It actually goes to the appellants, because if it's a practice of StormontVail to act this way, that neither addresses whether there were overcharges or the billing was correct. It's just a fact that does not dispose of this case. 15 and 16, just portions of some discovery responses, but nothing ever attempts to show any overcharges. 18 being recasting the plaintiff's petition. You know, it may be one thing to say that they don't collect co-pays in the emergency room as a matter of right, but in this case, they did collect a copay, and they weren't sued for asking for copays. They were sued for not applying the copay and then having someone in collection for the copay. And 19, another procedural fact. So I think what we have here is a situation where StormontVail knows or should know there was no absence of facts. And despite 4 motions to extend time to file a summary judgment, filed without leave. And
Ms. Huffman,
yes,
if I could ask you.
Of course.
I think the way these things usually work is that the motion for summary judgment is made, and there are some uncontroverted material facts that are claimed by the movement, and then it goes over to the response, and the respondent, in this case it would have been you, had an opportunity to controvert those facts, which was not done in this case. But the other thing you had the opportunity to do is to state your own uncontroverted statement of facts. Mm-hmm. And then it goes over to StormontVail, and StormontVail then can counter what they claim was not uncontroverted facts based on your part. My problem with your absence of fact theory is that I'm not sure what facts we have before us other than the facts presented by StormontVail. And then we have the law that if your claims can't be shown through the evidence at hand, the defendant can say they haven't made their case. It's your burden of proof to prove these allegations. And it just seems to me that we don't have any evidence of the claims. I understand what your claims are: deceptive billing practices, bad faith. But there's no evidence before us as an appellate court or as the district court to establish your claims. And I think that could be fatal.
Yeah, and I'm understanding what you're saying, but I take just 2 points with that, sir. The
Okay.
first being on summary judgment, the rule in Supreme Court precedent says they have to establish their absence of fact. It would be their burden other than my burden to prove. So they did not do that. I mean, even at the Supreme Court level, although it's unfortunate that this didn't get filed properly by me, which I don't deny, that the response wasn't there as a response. The second issue, I believe, is it's arbitrary and capricious to ignore that within 16 days of that out of time summary judgment filing, there was a full presentation filed in the court record, although it was titled amended motion for partial summary judgment on the 21st of September. And it's part of the appendix, the uncontroverted facts at appendix 6. The appellants did in fact make a filing. That filing showed a set of uncontroverted facts, and that filing had evidence with it. Now, if the court had, which was requested, considered that as responsive instead of advancing partial summary judgment, then we would be in an entirely different situation. So unlike if it had been no activity by appellant, in this case, there was evidence on the record. There were also affidavits and a contract attached to the first and only timely partial summary judgment by appellants. So I would, yes, go ahead.
Counsel, I want to ask a question. Why do you call this an untimely motion for summary judgment by StormontVail?
Okay, Your Honor. So there's 4 motions for StormontVail to extend time. And those are identified in the appendix. The last motion for Stormont, the 4th one, to file for extension of time granted by Judge Tice, then it must be filed by September 4th. The filing that granted summary judgments in this case was filed first on September 5th. And so that was after the 4th motion. There was no pending motion to file in stanter or out of time. It was filed without leave. And largely then when we argued, which I'm not abandoning any of my briefing arguments, but that's not, you don't need me to restate the brief. But I would point the court, Judge Hill, to 6215. Defendants argue that it's okay because they amended their motion for summary judgment. And then I have pointed out to the court and cited the record that it is absent a September 4th filing, and their September 5th filing, the title does not say amended, despite asserting that to the court. And then I also argue then that cuts against the fact that I couldn't amend. So they're casting.
Did you make this argument to the district court?
Judge, I don't know if I made the argument. I don't recall where it would have been, and I haven't seen it when I was redoing, working on this. It's been a long time. I'm trying to refresh myself. But when I wrote the brief, I could tell that there was a lot of confusion on my part at the court level. So I'm not going to assert that I did, but I do take issue that defendants haven't acknowledged to the court it's untimely, but they argue that it was an amended motion because they know they were out of time.
Because I wanted to see if there was anywhere in the record where the district court addressed your argument that StormontVail's motion for summary judgment was untimely. Do you think there's anything in the record?
No, I mean, I'm happy to reread and submit it, but nothing jumps out, Your Honor, or I would tell you that for sure.
Thank you.
But I
That's what
do,
That's
Oh,
what I
go
needed
ahead.
to know.
thank you.
That's all I needed to know. Thank you.
Oh, excellent. So I do point out, though, that the primary issue is that even under Rule 141 in the statute, that by filing a motion for summary judgment, that those facts have to support summary judgment. 100% are uncontroverted, and they have no ability to address the merits. But prior to that, I believe that the affidavit on file, the Blue Cross Blue Shield contract, and other documents that were there do support the summary judgment. And I also then take up, even if this portion of summary judgment being uncontroverted to the 19th and largely just repeating plaintiff's petition, that 215 would allow us to amend the pleading. And that amendment was made within the 21 days and in time. And although defendants
I
argue
take it
they
that-
can- yes,
I take it then, counsel, you consider a motion for summary judgment as a pleading.
I do, Your Honor. I do.
All right, Ms. Huffman, your time has expired.
Thank you, Judge.
So you will have 7 minutes in rebuttal. Ms. Shepherd? I think you're on mute.
You'd think after all this time, I'd remembered not to unmute. The issues that are before this panel to resolve are whether KSA 6215 applied to plaintiff's attempted amended motion for summary judgment, whether plaintiff's amended motion for summary judgment complied with Rule 141 so that it could have been considered a response to the defendant's motion for summary judgment, and whether the defendants met our burden, or the defendant met our burden to show that there was no dispute of material fact left to go to the jury, and whether the defendant showed there was no issue of material fact, which then imposed the burden on the plaintiff to come forward with evidence to show there were disputed material facts. Yes, Your Honor.
So if I could, before you dive into all of those issues, I would ask if you would clarify for me this idea that your motion for summary judgment, or StormontVail's motion for summary judgment, was untimely, and if that issue was ever addressed by the district court, and whether we should consider it.
All right, I will do that. The defendant's motion was actually refiled on September 5th, on September 4th when it was filed. Not all the pages of the exhibits were numbered, but the filing date is September 5th. However, it was not brought, that issue was not brought to the district court at any time from the date that it was filed, which was September 5, 2018, through the date that it was argued to a different district court judge on September 6, 2019. And the options, the times that it could have been addressed include when it was filed. There could have been a motion to strike or an objection as untimely. That was not done. The plaintiffs did not object when they filed their amended summary judgment motion on September 21, 2018. They didn't object when they filed their motion for additional time to respond to defendant's motion on 10/25/18. They didn't object or raise the issue to the original district court judge, which was Judge Tice, when defendant provided a letter to Judge Tice on 11/5/18 saying, we've submitted our brief, plaintiff didn't respond, we think this is ready. There was no response by plaintiff at that time. It wasn't raised when we had a conference call with court staff to set up the oral argument with Judge Watson, who took over the case after Judge Tice retired. The plaintiff did not move to strike.
to make a long story short, and so you can get back into your argument, the district, it was never raised in the district court as being untimely, and the district court did not address it.
That is true. It wasn't raised, wasn't addressed. It's not
So-
anywhere in the record, including the transcript.
So I take it you consider that issue waived.
I do. It can't be brought up now if it wasn't brought up before the district court. That's the law.
Thank you, counsel.
I also consider plaintiffs' appeal on the failure to grant their partial motion for summary judgment waived because it was not briefed in their appellate, in their original or initial appellate brief or in their reply. Things were briefed and there were arguments made about the allegations, but plaintiff did not address the issues of their motion for summary judgment, motion for partial summary judgment in any of their appellate court briefing. And so that issue, although it was included in the issues to be determined on appeal, was waived when it was not briefed for this panel to consider. Okay, we've addressed, I think, the issue of the 9/5/18 filing of the summary judgment. It is not before this court because it was not before the district court. And then the issue of 6215 and whether plaintiff's amended motion for summary judgment could be considered. There was a question about whether a motion for summary judgment is a pleading, which can then be amended under 6215 and under 6207. Summary judgment motion is not a pleading, and that is what we argued to the district court, and we continue to argue that here. And there has been nothing presented by the plaintiff to change that. There's some argument about the fact that defendant early on filed a motion to dismiss and amended it, but it was a motion to dismiss and it was quickly amended. It was not a motion for summary judgment. So that issue, plaintiff has not provided a reason for this court to say the amended motion for summary judgment should have been considered because it was filed, it could be amended under 6215. And that is what the district court found. But the district court also found that that amendment did not comply with the summary judgment requirements of Rule 141. There was not the, as was earlier raised, a response to each of the statements of fact that the defendant included in our motion for summary judgment. There wasn't anything. What was filed was a motion for partial summary judgment that dealt with completely different issues. The issue on our summary judgment was whether the two plaintiffs could proceed with their claims. The daughter, Laurel, we argued, did not have standing under the KCPA at all. And the district court accepted that. And she was not provided, I'm sorry, Judge Watson was not provided with any evidence to the contrary. Likewise, we provided Judge Watson with facts, law, and argument to show that the consumer protection claims that the plaintiff Donna Huffman was making were barred by 5635 because they actually were disguised medical malpractice claims, or at a minimum, they arose out of claims that medical care was inadequate, therefore you couldn't charge for it. Those were the issues that, in a big nutshell, that were before the district court. And as you know, the district court granted summary judgment based on the facts and arguments that defendant included in their summary judgment. So we have 165 complied with, which has been another objection. Did someone else start to ask a question? So I think we get down to what I expected would be addressed on this appellate briefing would be whether the district court had a valid basis to grant summary judgment for the defendant based on the briefing that we submitted. But that isn't really what happened. Instead, it was more a matter of arguing the facts in the, or the allegations at least, in plaintiff's petition and saying that's where StormontVail went wrong. Instead of backing up a few more steps and saying no, or addressing or responding to defendant's argument that we can't even get to those minute facts because these matters cannot be raised as KCPA claims, which is what the court, by accepting our motion, that was what the ruling was, and that was not addressed in the appellate briefing. Instead, it seemed like the things that were included in that amended motion for summary judgment, those were addressed, but that's the wrong level of issue as I see it. We needed to be taking the bigger picture and determining whether the ruling of the court on defendant's summary judgment was correct, and that didn't happen. So that leaves this panel with no evidence to overturn the district court ruling. And the court has no issue before them with regard to the filing of our summary judgment motion, or even whether plaintiff's partial motion for summary judgment, which was initially filed on August 31, whether that should have been granted.
Counsel, I have one final question for you. It has been argued many times that before us that a district court's findings of fact must be supported by substantial competent evidence. And we deal with that all the time. But does that standard apply when we are considering and reviewing a motion for a summary judgment that has been granted? And if so, what is your comment?
I think the standard is whether the summary judgment should have been granted based on the facts, law, and argument before the court, before the district court. And that is how it was ruled on. And then I'm not sure if this is exactly what you were asking, but it's been an issue raised. We met that burden to show that there were no material facts in dispute for the issues that we raised in our summary judgment. That then shifted the burden to plaintiff to come up with evidence to show that our facts and arguments were wrong, and that did not happen. So now that leaves this appellate panel with looking at whether what was in defendant's brief was adequate to obtain the summary judgment that was granted, and we submit that it was, and you haven't been presented with any evidence to show it wasn't.
Thank you.
The issues that were resolved on summary judgment were totally dispositive because the district court found in favor of defendant. There was nothing left to be presented to a jury, and that's why the case was dismissed. It wasn't a matter of we resolved some issues, but not all, and we should have then dealt with other parts of the KCPA claims. That did not happen. So our position is the summary judgment was appropriately granted, and the details for that are contained in the motion for summary judgment adopted by the district court judge, and we ask for that to stand on appeal. Thank you.
Counsel, thank you very much for your argument. Ms. Huffman, you have 7 minutes.
Thank you, Your Honor. I did take a little issue that the appellate's brief didn't address some of these issues because the briefing of StormontVail indicated that everything had to be the day of the accident, that nothing could be after. In fact, we've briefed before, during, and after. Via Christi, which was acknowledged by the defendants, indicates that billing for hospital is something covered for the KCPA. Absolutely, we have retouched on Via Christi, and what was left open and addressed with the undercourt and part of the notice of appeal is that defendants never even sought summary judgment under 5627. So the unconscionability claims that are based largely on an express patient bill of rights given by StormontVail have stood unattacked, and frankly, it was erroneously dismissed. And that's critical because that gets us back to remand, at least on that portion of the KCPA. I understand that am feeling like I understand that I'm hearing Ms. Shepherd argue that hospitals can't be responsible for KCPA on medical bills. But the fact of the matter is, the district court said she reviewed the amended partial summary judgment, and it wouldn't have changed her mind, which does indicate a problem with the evidence and the predisposition to dispose the case, because it never really addresses not even the entire case, but not even all the claims in the case. So as we sit here today, there are claims that are undisposed because defendant didn't seek them. And that in part is part of the KCPA. The idea that everything becomes malpractice because it comes out of the hospital attacks the Via Christi case. But unlike Via Christi, and unlike many KCPA cases, Your Honor, and as was argued largely before the district court, because she accepted the oral arguments for some of the facts in the amended petition for summary judgment, is that StormontVail is making these express promises in writing, which appear in this appendix, which were part of the petition. When StormontVail comes to the court and asks for summary judgment, they have a duty to believe that there's no outstanding issue of fact. They ignored the discovery, they ignored their own billing, they ignored quite a bit when they just had the 19 facts. So I would urge the court to remember, despite plaintiff's failings, the document that didn't meet the 141 response was for only two reasons. One, because it was titled Amended Partial Summary Judgment, and a title shouldn't matter to the substance of the evidence. And secondly, because it didn't say that each 1 through 19 were uncontroverted. If I had tried to controvert and done it faultily, the court would have found them uncontroverted. So I stood before the court, made an express argument that every one of the 19 would be found uncontroverted, which is something we can do at that stage. The rest of the pleading, which was 16 days after September 5th, which would have been well in time, then was ignored. And that
Ms.
also
Huffman?
ignores the affidavit earlier that talks about overcharges, because the August 31st affidavit on record, properly, timely on record as an affidavit on file, addressed overcharges. Defendant never did.
Ms.
So
Huffman?
not only as a matter of equity, but as a matter of substance over form. I mean, I urge the court to consider that, and I don't see that they're prejudiced because they never met the initial burden of substantial competent evidence, and they left the good faith and fair dealing contract claims and 5627 unconscionability claims untouched in their briefing. So despite having a journal entry disposing of the case, that in itself was erroneous, Your Honor. So
Counsel,
yes.
Counsel, got a question. You clearly were concerned about what you said were overcharges in this particular case. What is the amount of controversy with regard to those overcharges? What, how much are you alleging that you were defrauded in this particular case?
Sure, Judge. I have the amount that went into collection was under 100, but I had paid the 100. So that was one of my issues, was being in collection. But in Appendix 6, one of the uncontroverted facts that I asserted was that I paid, StormontVail collected at 24, uncontroverted fact 24 under billing. StormontVail collected $2,906.26, was $1,512.02 more profit for the same service than the amount collected. And then I also have a claim that even though I paid $100 copay and my contract was on file on August 31st, Your Honor, my specific policy with Blue Cross and Blue Shield required that if they turned in the bill within 60 days, my out-of-pocket for the whole accident would have been $50. Unusually good insurance in that situation. But instead, because they failed to bill, and it's part of these uncontroverted facts, until February, instead of in August, because they wanted to bill from Farm Bureau under my theory, because they didn't have the same contract with Farm Bureau, then I ended up paying, my 20% up to my $3,000 and lost 100% of my PIP that I could have used somewhere else. So it cost me thousands of dollars for them to fail to bill on time. So I hope that that's responsive to your question, Your Honor.
It is. Thank you. And I'll give you 30 seconds to wrap up.
Thank you, Your Honor. I think that the case sat out there a long time. It's an issue of both law and equity. I think when we look at it, I had asked the court to be kind because I did my best, maybe failed at it, but this wasn't a case that someone didn't respond. It was there in 16 days. And it doesn't matter if I controverted or uncontroverted the 19 facts. They have nothing to do with what StormontVail was sued for, and none of them dispose of the issues. And I sincerely believe that with the pending 5627 claims that were never addressed in the brief that should be remanded, we should be dealing with these contract claims and other KCPA claims as a matter of equity after all these years, because they did have this information in their possession and discovery responses when not only it was granted, but when they filed for their motion, they knew this was out there. And I take issue with advancing to the court that there was an absence of fact with these facts. So I urge the court to remand, and I appreciate you granting an oral argument.
Very well. All right, counsel, thank you very much for your arguments. Appreciate it. And we'll take the matter under advisement.